I have never seen anything quite like this. Today, we are talking about Michael Proctor. It is Tuesday. It's October 21st. So we are going to talk about what happened yesterday with Michael Proctor. We are going to talk about the run-up to what happened with Michael Proctor, because he's not fighting to get his job back anymore. But that's not even like the main point. And there was an afternoon court hearing yesterday that is adjacent to all the other Proctor problems. And we have to talk about that. So much has happened between the end of last week and yesterday. It is wild. So we are going to talk about all of the fallout. First place I saw this was from Ted Daniel. Here's the paperwork from Civil Service Commission showing Michael Proctor is no longer seeking to get his job back with the Mass State Police. Proctor was scheduled to have 3 days of hearings beginning tomorrow. Those are canceled. Yeah, he gave up. He withdrew his appeal. He gave up. We're going to talk about why. This is, as best of facsimile as we can get, but it says withdrawal of Civil Service Commission appeal. It's dated 10/18. Make an asterisk because 10/18 is going to be incredibly relevant. This notice confirms the withdrawal of my appeal in the above referenced matter. I exercise my right to sign this form of my own free will. 10/18, Proctor, name, address, email address, blah, blah, blah. That was posted after Ted Daniel had posted breaking. Michael Proctor's attorney, Daniel Moynihan, confirms for me that Proctor has dropped his appeal to get his job back with the state police. Karen Reed investigator Michael Proctor drops Mass State Police firing appeal. That's not the headline that I want you all to see. Proctor attorney Brian Moynihan said Monday that the team withdrew the appeal after receiving a recent disclosure from the Norfolk County District's Attorney's Office. He didn't share details on what that disclosure was. Oh, but we know, because today we're going to talk about what that disclosure was. We don't know all the deets, but we have enough information to make some educated conclusions. This is the only place I have seen this attorney quoted on why they withdrew, because every other outlet I have seen this attorney say no comment. But we know this is true because Friday is when those documents hit the docket. And those documents involve Proctor's cell phone. And not just what was given over in the Karen Reed case, but a substantial amount more. New statement from Karen Reed's attorney, Alan Jackson, on Michael Proctor withdrawing his appeal to get his job back with the state police. Michael Proctor's sudden withdrawal of his appeal wasn't an act of humility. It was self-preservation. Well, no shit. He learned investigators have recovered text messages from his private phone dating back years. And he wanted no part of what those text messages would reveal. He didn't accept accountability. It hunted him down. And as Colonel Noble has admitted, the years-long corruption is systemic. So on Friday, prosecutors turn this over to the defense attorney in numerous cases. They're all titled for their own cases. Commonwealth's notice of discoverable information from former MSP trooper's personal phone. Pursuant to orders in Commonwealth versus Miles King and other cases, footnote 1, and then all those cases are listed, including Johnson, Sinchero, and De Los Santos, and Walsh. The Commonwealth began examining an extraction from a personal cell phone of former Trooper Proctor for information reasonably believed to be discoverable under the Massachusetts Rules of Criminal Procedure 14b2. Due to the unexpected volume of files discovered on the phone, review of the extraction is not yet complete. The Commonwealth is attempting to produce information it currently believes to be discoverable by October 24th, but requires additional time to complete its review of the data extracted from the cell phone. This is the prosecution saying, this exists. We can't even turn it over yet because we haven't finished reviewing how much might be discoverable. And they can't just turn over all of it. Upon filing a motion, an amended motion for clarification by Proctor's counsel on August 13th, 2025. Remember, Proctor was fighting over his personal cell phone. He was fighting to limit this. Proctor's counsel on August 13th filed, and the judge responded that, quote, the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range. If you're a defense attorney, Proctor's attitudes about defendants, about people he's investigating, if I'm a defense attorney, I'm saying all of that's relevant. And if I'm a defense attorney, I'm also arguing, look, even though he might not have said it about my defendant, him saying this about another defendant close in time shows the perspective, let's be generous, the perspective, the lens through which he is viewing the world. Information favorable to the defense is incredibly broad. And if I were the defense attorneys, I would be like, The judge went on to say, Proctor has a legitimate interest in protecting any attorney-client or spousal communications. Fair, there's privilege there. The judge ordered that by certain dates, 1, Proctor provide his cell phone to the Commonwealth, 2, the Commonwealth extract a full digital copy of the cell phone, and then provide a copy to Proctor's counsel for a privilege determination and return the cell phone, and then counsel provide a privilege log to the Commonwealth. So the defense attorneys say to the Commonwealth, these are conversations with wife. These are conversations with not just a lawyer, his lawyer. And 4, the Commonwealth shall search the cell phone extraction with the exception of the communications identified on Proctor's privilege log. So now Proctor has to rely on someone else saying, yeah, sure, we won't look at the privileged stuff. The way that Proctor said, yeah, sure, I won't look at the communications between Karen Reed and Yannetti. And as to conversations with his wife, it would probably be pretty easy if it's just a text. It will get a little more complicated if there's group texts. Because a group text, Proctor talking to his wife and his wife talking to him, I think there's an argument that because it's a group text, it's not privileged anymore. It's not just a direct communication. Other people now know about that communication. So depending on that, it could get complex. And we know that Proctor's in a group chat, at least one, if not more. I would imagine there's more. At least these are going to be under a protective order. But if he went to a televised hearing and the civil service was going to be televised, it's going to come up. Do we see why the day after this was filed, Proctor and his attorneys went, nope? That's the August 13th order. So June order clarified in October. The court said, mention it all. The Commonwealth proffers that it has, so this is back to the motion. And this is not the Commonwealth quoting from the court's order. This is the Commonwealth telling the court. The Commonwealth proffers that it has received Proctor's cell phone, that an extraction has occurred, that the phone was returned to Proctor, and that Proctor's counsel provided a document entitled Privilege Log on the court-ordered date of September 26th. The extraction has yielded hundreds of thousands of items, some which date back as far as 2013. The volume of items, the motion goes on to say, was unexpectedly larger than the representations of Proctor's counsel regarding the cell phone footnote 2, and this is where the tea gets hot. We did not cover all of the back and forth on Proctor's cell phone. We had so much else going on in court coverage, and I was like, we'll just figure out what the result is when we get to it. Well, the result is holy fucking shit. Footnote 2. Proctor's counsel on July 25th and August 12th, 2025, filed a motion and an amended motion for clarification, which noted that Proctor changed phones in February of 2024. He did not preserve his old iPhone, and after activating his new phone in 2024, used an auto-delete feature, deleting the contents of his phone every 30 days. Counsel proffered, quote, therefore, regardless of the timeframes for the court's order to be clarified, it is I can't yell in the footnote voice. It is unlikely that Mr. Proctor has any relevant information in his possession concerning this case. How surprised did you think they were when the extraction yielded hundreds of thousands of items going all the way back to 2013. Proctor's attorney, in the opening statements for Proctor's civil service hearing, said that when Proctor was called into the federal grand jury, he didn't know. Proctor didn't know until he got on the stand at the federal grand jury that they had his texts. He had no idea that they had gotten his phone information. They didn't do a physical extraction of his phone. I'm pretty sure they must have done an iCloud extraction because he didn't know. He hadn't turned over his phone. Does he walk out of the grand jury and into like the Apple store and is like, I need a new phone? Because that's right around the time that he did the grand jury stuff. The DA's office is going to have an absolute nightmare on their hands dealing with this, because if the DAs find things related to other cases, they are going to have to turn it over. If they find things related to closed cases, cases that pled, cases that went to trial, they are going to have to turn over in how many cases Proctor handled. And they could end up having to turn over more to Karen Reed, because if Karen Reed is going to sue Proctor and there is more related to her case, this may all have to come out in civil discovery. Who else is this phone extraction going to take down? Because this is the very tippy top of an iceberg that's going to have some extensive ripples. So back to the unexpectedly large volume. Proctor said it was all gone, and it's not. Review of the extraction is underway, and the Commonwealth has identified materials that it reasonably believes to be discoverable in the King matter and in other cases where Proctor was a witness. And then they cite case law saying disclosure of exculpatory information arising from unrelated grand jury proceeding, part of prosecutor's official duty, and may be disclosed without order of court unless prosecutor seeks a protective order limiting disclosure. In addition, where appropriate and consistent with the Commonwealth's obligations, the Commonwealth will produce pertinent information to individual law enforcement agencies. The Commonwealth further proffers that it reasonably believes it will be able to and is making efforts to that end to produce information deemed to be discoverable from the texts, chats, and video, audio files from the extraction of Proctor's personal cell phone on October 24th, 2025, footnote 4. The Commonwealth will produce the privilege log to counsel in this case upon authorization by the court. The Commonwealth is requesting additional time to comply with the order in King and other cases to review other files on the extraction from Proctor's phone, including emails and photographs. Interesting that they need more time to go through all of the photographs and all of the emails. The Commonwealth anticipates continuing the review and providing those materials to the defense in this case as soon as practicable after October 24th. This is from the Miles King case. We're going to go look at the hearing involving all of this. But we do see that at the end of all of this, this is today, the 21st, the Commonwealth's motion for protective order for federal grand jury materials. So the federal grand jury materials with protective order. The hearing from yesterday that we're going to go watch. The notice of withdrawal filed. 10/20 attorney appearance. On this date, Daniel Moynihan Jr., Esquire, dismissed and withdrawn for witness Michael Proctor. His attorney rehomed himself. The notice of discoverable information is filed Friday. Saturday, they signed the withdrawal of the appeal. Monday, he withdraws from the case. The attorney's like, good luck, buddy. My interpretation.
Your Honor, Judge Casper issued an order on Friday, which allows the Commonwealth to provide.
This is regarding the discovery order from a different judge.
To the defendants who the cases were in the cases that were called, in addition to some other designated defendants. The order allows the Commonwealth to produce some grand jury materials to the defendants in those cases, provided that they are filed under seal.
Note that she said some grand jury materials. to the defendants. These are from the federal grand jury. So federal grand jury items are being turned over to some of the defendants. That would have come from the Karen Reed grand jury. So I imagine we are also talking about Proctor texts. And those are going to be turned over.
The order that was issued on Friday, we are also allowed to produce to the parties in the court as long as it's filed under seal and an index. Again, as long as it's filed under seal. So I have those materials present for the people who are here today, and logistics are making this a little bit complicated for people who aren't present. We've already reviewed all the materials, and we had done that prior to the last court date before then. Right. We are only permitted to provide to defense counsel certain materials. These are the only materials that we sought permission after our review to provide. That is to say,
the prosecutor just said we're only permitted to turn over these certain things because that's what we asked to turn over. So we asked for this and they said yes, but we didn't ask for all of it. You didn't seek all of it. There may be things in the Reed case that are not relevant to the other cases, but saying we chose to ask for some of this and not all of it is a precise narrowing of the scope of what they asked for.
My understanding of the order was that under the umbrella of grand jury, we are going to receive these materials, which would include all of the grand jury from the federal court, including any and all exhibits related to Trooper Proctor. It is my understanding, though, that there are additional...
There may have been more than one exhibit.
Right.
One exhibit.
There are materials outside of what actually was presented in federal court that we are also going to have access to, and that would be information from the cloud and the personal cell phone of Trooper Proctor, if I'm understanding.
Well, there's some new information there. We knew, right? We could all guess where the Trooper Proctor information came from. But the defense attorney's like, well, we thought we would have all the grand jury materials related to Trooper Proctor, all the exhibits related to Trooper Proctor. We thought we would have all of that. But the defense says, we are also going to have the information from the cloud, from Trooper Proctor's personal cell phone.
because we want to be clear, as clear as we can be and as clear as the federal government will allow us to be. We sought permission to have the index, which I think is something that was discussed in hearings previously. So we also will have the index, which gives some idea of materials that we did not seek authorization to provide and do not have authorization to provide and are not providing. And then...
and that's the index of other materials.
Correct.
Okay?
That's from the federal case.
Between the stuff that is authorized to be produced and will be produced, subject to a protective order, and the index, the defense will know all of the stuff that you reviewed.
And in addition,
is that right?
That's correct. That's the intention. Is so that there's not a dignistory about what the other materials were. And in addition, and why those, as outlined in the U.S. Attorney's Office letter, why those other items are not Rule 14 material in these cases.
I'm sorry, the index indicates why they are not Rule 14?
It provides, the index itself doesn't provide that, but reading the index, I think, provides some information about why they're not Rule 14 material.
Okay.
And then...
When she says not Rule 14 material, she means not obligated for the District Attorney's Office of Massachusetts to turn over.
Finally, the order now contemplates, or orders, a return to destroy date of the other materials of October 31st.
I do have some concerns, obviously, in
The defense.
thinking about a reservation of rights.
Of course you do.
On behalf of the defendants, because we're in this unique position here where the government is really the arbiter of what is or what is not Rule 14 exculpatory information. My concern is once we start getting into the actual discovery, it might become obvious to us that other information is out there that is not discovery. It's a very difficult thing from the position of a prosecutor to make a determination, not knowing the defendants and the defendant's theory of the case, what is or is not exculpatory. So I am concerned with these, quote, other materials being destroyed on October 31st, and I think there should be something put in place where we can at least have those documents set aside, not subject yet to any type of disclosure, but set aside for a potential future review.
So the defendants have had the ability to make TUI requests, to seek to intervene, and have not. We are confident that we have met our Rule 14 obligations, and I would tell the court, and the other assistant district attorneys who participated would tell the court if they were not confident. And again, I think the index will be helpful, and I'm able to provide that index today.
I think what I would do is, in an abundance of caution.
Yep, we would love that.
That's my better judgment, because I really don't want to have another hearing on this. But I will schedule a time to see anybody who wants to be heard on the issue of the other list sometime next week, after you folks have seen it and have had a week with it, to consider whether you think there's anything that we need to bring to the prosecutor's attention about the things that might be on that other list.
The index.
You obviously don't have the other list, so you're shooting blind right now.
Yep.
You'll have it today, and you'll be able to come to some sort of conclusion as to whether you think, given the information on that list, you have some reason to believe that it would contain exculpatory information.
So we went to court. We reviewed the hearing from the 20th. What did we learn in the hearing from the 20th? Well, they mostly discussed the federal materials from the Karen Reed case. What materials will be given to the defense attorneys in the Miles King, Brian Walsh et set cases? There are 5 of them that Proctor is involved with, where these materials are being turned over. And the prosecutor said, Your Honor, we have a federal protective order. We are allowed to turn over these 2 categories of materials. We reviewed, which was the first fight. The first fight was that the prosecution wasn't even allowed to review the federal materials because there was a protective order that only the prosecutors in the Reed case could review them, and the prosecutors in the Reed case weren't on these cases and then couldn't disclose them. So the prosecutors were like, we need to review it and determine what is discoverable to these attorneys in these cases. And the prosecution came into court on the 20th and said, we reviewed all the federal materials now that they finally got permission to review them. And we sought discovery of these few limited categories of items. And we were given permission to turn over the items that we asked to turn over under protective order. And we were given permission to turn over the index from the grand jury, from the feds, to show what items there are that the defense does not have. So what the court says is, you know what I'm going to need to do, and I don't want to do, but what I'm going to do is give the defense the index today, let the defense determine if there's any items in there that they might need to ask for, and go from there. So let's all meet back here next week on the 30th at 2 p.m. because then the defense will have had time to review the index. And after the defense has reviewed it, then they can say, hey, we would like this. And what we heard about again was this like destroyer return date where the feds, when they turned over their grand jury information to the prosecutor's office to review, there was a deadline on that. Hey, you need to give us back this information or destroy it out of your system by this date. That is set by the feds. Some of that information is being turned over to the defense in these cases. That's in addition to the new information. And the defense said what most of you said in the chat, because chat is wise. And chat said, but if you're the defense attorney, you have to just believe that the prosecutor looked at all of this and said, yeah, you don't need this. Yes, you do need this. And you have to request additional information that you don't know exists. Yeah, that's about it. And so the defense said, Your Honor, I have questions. How are we going to object if we think that there is more in the federal case that the prosecutors didn't ask for that we should have? And the prosecutor's response to some of that was, well, the defense can make two-way requests to the feds and then get the discovery from the feds. And the defense is like, but if there's more that we need or that we think that we need, how can we even request it? And so they set another hearing. But guess what they also said? Your Honor, we know that this is what's coming from the feds, the grand jury materials, the discovery materials, discovery/TUI. But we also have all of the other information coming from Trooper Proctor's personal cloud. All roads point back to Trooper Proctor's phone and Trooper Proctor's personal phone. And I hope that on the 30th, or at least from the hearing on the 30th, we will learn more about what was extracted. We have gotten like little nuggets of information with regard to Trooper Proctor's federal cell phone discovery. The federal cell phone discovery, Trooper Proctor didn't even know about until he was a witness at the grand jury regarding the Karen Reed case. So Proctor got blindsided as a witness at a grand jury with his personal cell phone information. And then his attorneys said to the court, I mean, you can order that they go get his cell phone, but he got a new cell phone in 2024 and there's not going to be anything there. And then there were hundreds of thousands of things in the return, some dating back to 2013. The Commonwealth noted their surprise at the voluminous discovery that they recovered from Trooper Proctor because he said it was auto-deleting and that there wasn't anything there. I wonder what the defense attorney said to Proctor when the prosecution came back and said, hey, so you said he got a new phone in 2024 and everything was like auto-deleting. And after the Brian Higgins cell phone and the Brian Albert cell phone, after all the other cell phones, I imagine that the prosecutors are like, there's not going to be anything there. And then the defense attorneys can do whatever, but there's not going to be anything to discover. And then they got so much information that they now have to go through and turn over. They got texts, chats, which I think is separate from text, videos, audio, photos, and emails from Proctor's cloud storage, which is what it seems to be. The prosecution is going to have quite a lot to go through and turn over. Trooper Proctor is going to be real unhappy about all of it. Trooper Proctor withdrew his appeal, and I think we are just at the tip of the iceberg with where all this goes. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.